All right, we'll come to this in a minute and then take it a little further. What to expect, or how will it play out if the lawmakers bring the provisions of the card reader to the Electoral Act and make it acceptable by law? But just hold on a minute. Let's get back to examining the court judgments that just was handed down by the Supreme Court on Rivers, Ebonyi, and Ogun. We're flipping back to Mr. Daniel Bwala, who joins us from Abuja. Well, let's look at this scenario. If eventually it's recognized by our laws, the lawmakers make that amendment, that will be electronic voting, wouldn't it? And if that were the case, how do you think this will help, having seen the judgments as they've been delivered?
Well, if a judgment is delivered, you can't visit it in retrospect, but you can correct the situation in the future. However, if the National Assembly amend the provision of the Electoral Act relating to ascertaining the legality of votes and the result of votes, they do not have to take away the manual register of voters, but they may need to incorporate the card reader and the manual register of voters and carry them along. And then if the amendment is such that we want to completely jettison the manual card reader and rely on the manual means of register and then rely on the card reader, then that means we have to test run it from now before the next election to be sure that we have achieved 70 to 80% of the success rate of the card reader. Because in Shinkafi and Yari, the Supreme Court said that the card reader is merely to authenticate the identity of the person who comes.
Yeah, and you know, I do remember that before that election, the INEC chairman, Professor Jaga at the time, had appeared before the Senate, and they did ask him if those were recognized by law, if it was going to be admissible, and I think it was in the negative, his response. And so would you then say it was mischievous for people to want to rely on the card reader perhaps as the sole reason why they should declare them either winners or losers?
I don't want to assume or say that it is a mischief because, first of all, the card reader was not produced by any political party. There is no any chip inscribed or inserted into the card reader that will reject a political party and accept another political party. And thirdly, INEC is not a member of any political party. When the card reader was introduced, the assumption is that the card reader will do justice by avoiding a situation where someone who did not register will come to vote. These are the malpractices, that we thought we could resolve. But the card reader, by the decision of courts now, have not. Rivers recognized card reader over and above register of voters. Lagos rejected card reader and then rely on the register of voters. The Supreme Court said the two of them are to be carried along. So it seems this year, no tribunal or court of appeal accepted the two together. It's either you are for or against the card reader. And it appeared by the decision of court that majority of the decisions have been against the card reader. And technically, that's how we arrive at the invalidity of the card reader as it were.
Isn't that because that is the one that is recognized by law, the voter register, and not the card reader?
Yeah, well, you are right, and you could be wrong as well. Because we all know that the register of voters has been. But the card reader was introduced in order to bring probity, in order to avoid malpractice. All right? So the card reader was not introduced in error. It was calculated. It was planned with the proper intention to solve the problem. The only unfortunate thing is that if the courts, for example, right from the tribunal, have carried the two along, we will find ourselves before the Supreme Court now rejoicing that the card reader and the register of voters have been carried along like the two wings of an airplane or like two wings working together. But it seems that the card reader was seen this year as an enemy of the register of voters. And the register of voter, continue to look at the card reader result as though it is, an innovation that was aimed at invalidating election of certain individual. But where I will prove to you that the card reader was not introduced to favor any party. The person who introduced, the administration that introduced the card reader was the administration that lost the election. So he couldn't have introduced a card reader if he knew it was going to work against him. So if you ask me, I would say we need an amendment. We need the card reader. We even need stricter measure if possible.
Okay, so my colleague already asked you just before we went on break. I think he was saying, how do you think this will play out at the National Assembly?
Well, the National Assembly, funny enough, are also members of political party who may either be rejoicing or mourning over the result that we have seen on the effect of the card reader. But whichever way you look at it, I believe that the National Assembly of the 8th session will have to do something about that. All of the problems we've had in the past, the National Assembly have sat and corrected them. So I know they are going to do it. And these are some of the issues that we expect the National Assembly to be engaging, not to be discussing salary. There are lots of innovation that they will come up with that will correct situation. So I believe that it will play out for good, because the card reader has favored both APC and PDP, has also affected negatively both APC and PDP. So it doesn't matter how the thing is brought to the National Assembly, they will have to do something about it, except if I didn't get your question correctly.
Well, I think you did get my question correctly. I'm just wondering how, because, and we do know that the INEC chairman has been speaking, the new INEC chairman, he's been speaking, saying that they're not going to bring in any new innovations. What they intend to do is improve. And it would seem that gradually we would move to electronic voting. That's what it looks like where we are going. Do you think that we'll be able to easily accept this?
I think we can achieve that. I have confidence in the administration of Buhari, because when he says something, he means it. And we have been seeing that in anti-corruption war. Sadly, in the economy, we haven't seen something that will give us a thumbs up, so to speak. So, and what the INEC chairman is saying is inconsequential. He's not a lawmaker. He's merely expressing his opinion. And in lawmaking, he doesn't have to bring a bill before it is passed. Members of the public can sponsor a bill, and then the bill becomes the law. And Nigerians are the ones that determine whether the card reader is important to us or not. So even if INEC is not conceiving the idea of bringing any innovation but to improve on what they are, if an innovation will be necessary in the circumstance, the law will have to be passed. But I also support what he said to improve on what we have. For example, the card reader. If we get as much as possible scientific or any professional touch to it, that the card reader will be test run, and we see that it works to a level that can be considered as 70 to 80%, then we will be good to go in 2019. But until and unless we do something about handling irregularity, ballot stuffing, multiple voting, the card reader was introduced to solve it. So we have to continue in this work, in this crusade, until the card reader works in this country. And we have to fight every effort to take away the card reader. So far, the courts have taken it away. So the National Assembly will have to bring it back to our electoral system.
Well, we'll be looking to see how the lawmakers approach this one, especially now that the next step that people want to see is electronic voting. But then, in terms of getting back to the classrooms, looking at all this judgment, how does this enrich jurisprudence and perhaps what you'll be telling students?
2015 is interesting, actually. And the decision of court has enriched our jurisprudence. For example, the Supreme Court has addressed question that the effect has affected people whose appeals terminated at the Court of Appeal, National Assembly election. For example, if someone at the National Assembly election, his election was annulled because a member of another political party challenged his qualification. Sadly, he's weeping now, he's crying because his appeal stopped at the Court of Appeal, and the Court of Appeal didn't give him what he wanted. But for the governors who have had the opportunity of going to the Supreme Court, in Yari's case and in Benue's case, they are rejoicing because the Supreme Court now has nailed the already principle of law in Onoha and Okafo, that party affairs are within the business of the political party. The other aspect is the issue of the card reader. The conflicting decisions of the Court of Appeal sadly is the bane of the problem in the country. But you see, you cannot challenge them because the court of a particular division of the Court of Appeal's decision will not bind another decision of the Court of Appeal of another judicial division because of the doctrine, of the principle of law that we have. They are not bound by that decision. It is merely a persuasive. But Supreme Court has corrected that situation. So we have the law, as it were, on that question. And then there are issues that people are challenging, even the decision of the Supreme Court. But those challenges will culminate into an argument that would enrich the jurisprudence, so that if in the future that matter is re-argued and not again in a perspective that would help the Supreme Court appreciate it in a broader perspective, then we are likely going to find the Supreme Court correcting their previous decision, because in our law, the Supreme Court is not bound by its previous decision, because Supreme Court can give a decision today and tomorrow depart from it if the Supreme Court is convinced.
All right, let's look at this matter. I mean, I heard you refer to the fact that it is a political party that presents candidates in your submissions. Put it in the context of Kogi and what's going on there, wherein, yes, you've seen the deputy, that's Faleke, who contested as deputy to the late Audu, and now he's asking for different things. He's gone to court to say, well, he should be declared as the governor, having won the elections. And then we have a governor who was sworn in without a deputy. So if you bring that point of yours in this context, how would it play out?
If you ask for my opinion, to be honest with you, activities in Kogi is strange to me. My belief is that Faleke is the governor of Kogi State by virtue of the provisions of the law that gives blessing to a joint ticket mandate. Because at the time the election was declared inconclusive, PDP was in clear lead. In fact, there is even an argument that INEC had already prepared to announce PDP as the winner.
You mean APC?
Then the second thing is, how could Mr. Bello go into election without a deputy against the clear provision of the Electoral Act? The third thing is, now he is even, but they say there's an argument that they are trying to bring another deputy. Whatever is happening in Kogi State, if it does not turn in favor of Faleke, it will be a free lunch to PDP as we go on with the cases, because he has been sworn in, but the case has not ended. Interpretation of the law is ongoing at the Court of Appeal, and that's how it will go on, and then we will get the decision of the Supreme Court regarding whether a candidate can go into election without a deputy.
Well, it's going to be very interesting. I mean, you say it's strange to you, and who knows what could happen at the court if it gets to the Supreme Court, or who knows what the party will say about this one, because they say, look, we are the ones to bring the candidate, but we'll see how those judgments eventually play out at the end of the day. Well, thank you for coming on this morning, Daniel Bwala, adjunct lecturer, Nigerian Law School, Abuja. We will be back in a moment. Don't go away.